In a criminal case, there's various kinds of admissible evidence. Depending on the circumstances, this can include things like video footage, cell phone logs, emails, fingerprints, and eyewitness testimony. But according to the Innocence Project, as of today, 71% of the 342 prisoners exonerated by DNA evidence were wrongly convicted based on faulty eyewitness testimony. That's not to say that eyewitness testimony is never reliable. In fact, in many cases, it can be the best or even only evidence available. Instead, the issue seems to be that we overbelieve this kind of evidence. Because we're not fully aware of our natural biases, judges and juries place more trust in eyewitness identifications than they actually deserve. And it's in this gap that miscarriages of justice occur. So, how exactly can eyewitness accounts be flawed? Well, for starters, memory is dependent on your arousal, or alertness. If you're getting sleepy, you're not going to remember much, but if you're wide awake after a cup of joe, you're bound to be more attentive. But beyond that, excess stress can actually hurt your ability to perform mental tasks. The stress described here in the Yerkes-Dodson Curve can come from all sorts of situations. An audience watching on as you compete in a game show, the prospect of failing a class, or the shock of being witness to a crime. In other words, your ability to memorize the details of a crime can be impaired by the very fact that you're witnessing a crime. But even once the crime is over, your memory is susceptible to more errors still. According to the Misinformation Effect, your memory of an event can be changed by misleading information given to you after the fact. Information in this case doesn't just refer to false statements. It also includes things like the simple phrasing of questions posed to you. Which is why, after seeing the exact same video of a car accident, people estimate faster speeds when asked about cars that smashed instead of hit. And what this all points to is that our memory is reconstructive. It's not static like some kind of videotape that can be popped back in and shown accurately at a moment's notice. Every time a memory is recalled, it's not played, but rather recreated in your mind like a puzzle. And each time this happens, the memory becomes fragile, susceptible to loss and alteration. So like any other kind of evidence, eyewitness testimony is subject to contamination, whether it's intentional or not. And it's important that jurors are aware of this before putting too much confidence in our memory. But we can do more than just trust eyewitness testimony more moderately. We can also use our knowledge of psychology to improve the way we handle such evidence, to make it ultimately more reliable and trustworthy. The National Academy of Sciences released a report on the use of eyewitness testimony in courts, identifying several key recommendations. Training law enforcement officers in how to handle eyewitnesses while minimizing contamination, for one, is a good start. For instance, during a routine lineup, something as simple as asking, "Who did it?" can actually imply the true criminal somewhere in the lineup, even if they're not, making it more likely the victim will pick someone and end up believing that's really who they saw. Lineups should also be double-blinded, meaning neither the witness nor the administrator should know who the main suspect is, to minimize verbal or nonverbal cues that may inadvertently bias the witness's selection. Lastly, it's important to document how confident the witness is when they're first brought in. In this excerpt from an actual Supreme Court case, jurors might see a confident witness, but not realize that the initial decision was made with a lot less certainty. Just as misinformation can affect our memory of a crime, so too can it affect our memory of how confident we are. So it's important to look at the witness's initial confidence, not how sure they seem months later. Now, these are not all of the recommendations suggested in the report, but it's a good starting point. At the core of all these recommendations is the idea that we can't, for now, change the way human memory works. It will always be highly variable and subject to error. What we can do is work to accommodate these flaws in our legal system by training officers, double-blinding lineup administrators, and documenting witness confidence judgments so that we get the best of what we do have.